Hey everyone, it's Juanita at Cape Fear Family Law. Here today with a case update. We're going to be talking about Mucha v. Wagner, which is a case that came out of the Court of Appeals in June 2020. It was decided by Judge Sasser in Wake County. The main ruling out of this case is regarding the long-arm statute of North Carolina. The long-arm statute, the court found, did extend to a defendant whose only contacts with our state was through phone calls made to the plaintiff when he didn't know she resided or had moved to North Carolina. The court still found that the state had jurisdiction to enter a domestic violence protective order. So today we're going to sort of pull that case apart a little bit. I will caution anyone watching this that the court, in its ruling, at the end of the case, the court did say that this was a very close case and that it was very fact sensitive, and that there may be other instances where phone calls to a person who resided in North Carolina would not reach the threshold for that long-arm statute. But in this case, the court found that it did. So to give you a little background, factual history, Mucha, the plaintiff, and Wagner, the defendant, were involved in an intimate dating relationship. Mucha resided in South Carolina as an out-of-state college student, attending school there. Wagner resided in Connecticut. There is some evidence, although it's minimal, that Mucha would travel out of state for visiting family, so clearly her family didn't reside in South Carolina. Some of those families did reside in Connecticut. The parties separated or split up in 2018. There is some anecdotal evidence that it may not have been a very friendly separation. Mucha had testified that she had suffered severe panic attacks when she had to speak with Wagner, and she had asked him multiple times, in court outlines at least two, where she had told him to stop calling her because she was having severe panic attacks. Fast forward a little bit to May of 2018, and Mucha has posted something on Facebook that says her semester's over and it was a tough semester, it's time to leave school, basically indicating that she was leaving college. And on her drive to North Carolina, she receives 28 phone calls from the defendant. The first several phone calls she didn't answer. They were from an unknown number. She answers one, immediately discovers who it is, tells him not to call, hangs up on him. He calls again, she answers, she says, "Don't call me again." He continues to call again. It was a total of 28 times, one of which he left her a voicemail. Mucha then states that she listened to that voicemail, and there were some witnesses here in North Carolina who witnessed her reaction to that voicemail, which induced a panic attack for her. The very next day, she goes to Wake County, North Carolina, and files for an emergency domestic violence protective order. She was awarded that protective order. The defendant filed, after him being served, the defendant files a motion to dismiss. Both were heard at the same time. The trial court denied his motion to dismiss based on his allegation that there was lack of personal jurisdiction over him. The trial court denied that. And they granted her the relief requested under the domestic violence protective order. I think that this case is so important because we look at this and we think he, number one, had no knowledge that she was in North Carolina. As far as he knew, she was in South Carolina, although there's some evidence that he knew she was leaving school. He has never, according to what we do know, he had never been to North Carolina, didn't know where she was. Her family presumably resides in Connecticut, where she was visiting them at some point, which is where he resides. And so his only contact with our state was through 28 phone calls, some of which may not have even occurred in North Carolina because she was traveling to North Carolina. But the court found that that was enough. They reviewed the analysis of due process, the 5 factors that have been laid out by the Supreme Court of the United States and adopted and, of course, established here in North Carolina. They talked about the foreseeability factor. He should have been able to foresee that he would have been brought into court or hailed into court in North Carolina to defend his actions, that his actions were intentional, deliberate, and that they are themselves what led to the filing of the domestic violence order. So the court found that the trial court was correct. They affirmed it, and the decision stands. His motion to dismiss was denied, and the protective order was valid. I will also say, and again, this is just a little anecdotally, but I think that the court at this point felt as if, where else would she have filed a domestic violence protective order? Where would her relief have been? South Carolina wouldn't have had jurisdiction because the calls presumably didn't occur there. She wasn't there anymore. She had left the state. Connecticut had jurisdiction over him, but none of the actions occurred in Connecticut. She wasn't a resident of there. So if not here, then where? And I think that was, even though not stated, I think that was an underlying factor in this decision. But again, I'll caution everybody watching this that the court was very clear that this was a close decision and that it was very specific to these set of facts, and that in other circumstances, 28 phone calls may not be enough to meet the minimum threshold for minimum contacts. So for us family law attorneys and civil litigators, we have to look at this and think, will this have any impact on some of the heart-bomb statutes that we have here in North Carolina? Because one of the obstacles we face is many times the mistress or the third party lives in another state, and our client lives here in North Carolina. And if they live in another state, we may not have personal jurisdiction over them because they may have never stepped foot in North Carolina. The affair could have occurred in a foreign jurisdiction. Therefore, would we have established those minimum contacts? And I think that it would be important for us to look at this case and say, does this case open that door for us a little bit? Whereas if the communication between the third party and the spouse occurred in North Carolina, how much of that communication occurred, and does it help us hit that threshold to open some avenues for third-party claims here in North Carolina? And I'll be honest with you guys, I think it might. It'll be an interesting thing to see happen. So, ladies and gentlemen, if you should get anything from this, if you're having an affair on your spouse in North Carolina and you're getting some texts or videos or messages from your mistress or your third party and from another state, don't assume North Carolina doesn't have jurisdiction, because this case very well may have changed that. So thanks for listening, guys. It's always fun to talk to you. Don't forget to like, subscribe, comment, ask questions. We love to answer them. We love to hear from you. And hey, tell us about your contacts here in North Carolina that you think might be impacted by this case. Thanks, guys.